The case which shook the Indian legal system when two fundamental rights collided with each other. Number one, right to practice of religion, and number two, equality before law. The aftershock of this case led to enactment of a new law, and due to public unrest, the government had to settle the ignite by enforcing a new law. It is also a story of a woman fighting for her rights and millions behind them. Due to disparity and stringent personal laws, the void behind the gender was evident. This is the famous case of Shah Bano Begum. Let's understand the story with a series of events. Number 1. In 1932, Shah Bano, a Muslim woman, was married to Muhammad Ahmad Khan, a well-known advocate in Indore, Madhya Pradesh. They had 5 children in that marriage. After 14 years, Ahmad Khan again married a younger woman as second wife, and after years of living with both the wives, he abandoned Shah Bano. Shah Bano was aged 62 years and promised her to pay 200 rupees per month. In April 1978, he stopped giving the said money to Shah Bano. She filed her criminal suit against her husband under section 125 of Criminal Procedure Code for rupees 500 as maintenance. In consequence of that, in November 1978, her husband pronounced triple talaq and contended that she ceased to be his wife and hence he is not liable to maintain her, and gave her a meher amount of total amount 5,400, which was prescribed under Islamic law. In August 1979, the local court directed Muhammad Khan to pay a sum of 25 rupees per month to Shah Bano by the way of maintenance. Shah Bano approached the High Court for the increase in maintenance amount. On July 1, 1980, on a revisional application of Shah Bano, the High Court of Madhya Pradesh enhanced the amount of maintenance to 179.20 rupees. Afterwards, Muhammad Khan filed a petition to appeal before the Supreme Court, claiming that Shah Bano is not his responsibility to maintain anymore because Mr. Khan had obliged and followed the settled law of maintenance under Muslim law, which requires him to maintain till the iddat period of 3 lunar months, whereas Criminal Procedure Code mandates maintenance until death or remarriage of the wife. Now we move ahead to event number 2. On 23rd April 1985, the matter was then heard by 5-judge bench composed of Chief Justice Y.V. Chandrachud, Honorable Justice Ranganath Misra, Honorable Justice D.A. Desai, Honorable Justice O. Chinnappa Reddy, and Honorable Justice E.S. Venkatara Ramaiah, whereby following issues were framed. Number 1. Whether the definition of wife under Section 125 CRPC includes a divorced Muslim woman. Issue number 2. Whether Section 125 CRPC overrides personal law. Issue number 3. Whether a Muslim husband's obligation to provide maintenance for a divorced wife is in or in conflict with Muslim personal law. Issue number 4. Whether dower is a sufficient sum payable as maintenance. Upon these 4 issues, Supreme Court in an unanimous decision dismissed the appeal and confirmed the judgment of High Court. Now, event number 3. After careful deliberation, the Supreme Court ruled in favor of Shah Bano. The court held that Section 125 CRPC is applicable to all women irrespective of their religion. The justice reasoned that denying maintenance to a divorced woman on the basis of religion would be both unjust and contrary to the spirit of the Constitution. In a landmark passage, the court also referred to Quran, and the verses of Quran argued that Islam itself encouraged fairness and financial responsibility towards divorced women. the judgment declared there is no conflict between provision of Section 125 CRPC and both Muslim personal laws. Both are based on the obligation of husband to provide for his divorced wife who is unable to maintain herself. And the verdict becomes a milestone in the fight for gender equality and secular justice in India. But the story didn't end by that time. The story is more. Now we come up to event number 4. Due to political instability, gender discrimination, insecurity in religious belief and social stigma, the government had to bring a law. The law was Muslim Women Protection of Rights on Divorce Act 1986, which aims to protect the financial interest of divorced Muslim women. It ensured that divorced Muslim women are given their meher and a reasonable maintenance amount from their former husband. However, this act's provision for maintenance are limited to the iddat period, that is only till 3 months, under which the contrary to Shah Bano judgment. This led to a different event, and that was a huge setback for the judicial system. Now we come up to event number 5. Shah Bano's counsel, that is Advocate Daniel Latifi, filed a writ petition in the Supreme Court challenging the constitutional validity of the act, claiming that since the wife who was dependent on her husband prior to marriage has a right to life even after marriage, and with the view that the Act of 1986 violates Article 14, 15 and 21 of the Indian Constitution. It also contested that the Act being less beneficial than Section 125 CRPC by denying divorced Muslim women the same maintenance benefits as other divorced women of different religion. Later in 2001, a judgment was passed in Daniel Latifi case, which upheld the Shah Bano judgment, and rights of women was prioritized over strict personal laws, while granting the freedom to Muslim women to approach the court for their legal right to be maintained. I hope that this video suits you and this video gives you all the details which bring a change in our social reformation. Shah Bano, it's not just a name, it's just a revolution.